You are watching Morning Musings with Reinhard von Hennings, chairman and founder of Bridge House Law in Charlotte, North Carolina.
Is baby powder safe? Hello, this is Reinhard von Hennings. The question could also be asked, why did Johnson & Johnson pay $8.9 billion in a settlement? Johnson & Johnson had declared a few days ago that it would pay $8.9 million over the next 25 years in an attempt to settle all existing and future claims against the company's baby powder and other cosmetic talc products, which are alleged to have caused cancer. The company's subsidiary, LTL Management, Inc., would be allowed to refile for voluntary Chapter 11 bankruptcy to resolve any and all accusations, but this is not an admission of any guilt. Johnson & Johnson and its affiliates will continue to conduct their operations in the usual way without filing for bankruptcy protection. In a statement, the company denied again all accusations and claimed that any argument lacked scientific validity. However, the company wants to settle to avoid a lengthy process. And in my experience, when my clients discuss with me, should we settle or should we go all in, the arguments go both ways. Settlement is now and fast. Lengthy process is pain forever. So Johnson & Johnson's attempt to get this case out of the court system leads to a stop of a case which could decades to resolve. It could lead to significant expenses and therefore could lead to compensation too late for many of those claimants. The announcement followed a January 2023 ruling by a federal appeals court that Johnson & Johnson could not use the bankruptcy court to resolve about 38,000 lawsuits. Hey, it's a pretty tricky idea, right? I'm in trouble, so let's file a lawsuit. But here, the court denied it. So the court could not use bankruptcy as a way to avoid arguing that talc in its product potentially led to ovarian cancer and mesothelioma. At that time, the company declared its intent to challenge the decision. The critics were all over that a legal tactic is now used in order to detour the whole process, and that there are now other companies to follow the idea of jumping the bankruptcy route rather than to litigating it. Let's go back in time. In 2019, Johnson & Johnson recalled a shipment of baby powder. This baby powder had a sample which tested positive for a trace amount of asbestos. And according to the Food and Drug Administration, FDA, it was considered to be dangerous. There was an advisory out from an FDA that this should not be used by humans. Sales of the talc-based product came to an end in North America the following year, and in 2020, Johnson & Johnson made it public the decision to stop using talc in baby powder worldwide by 2023 and reduce the usage of asbestos to zero and now using cornstarch instead. In February 21, the US Supreme Court declined to hear an appeal about a $2.1 billion judgment, which was rendered in the meantime. The decision of the lower court now stood up, and Johnson & Johnson was heavily arguing that nothing is wrong with the matter and denied all allegations. Johnson & Johnson, the well-known multinational company, has been providing this powder for several years. For the past few years, the company was embroiled in a legal battle that the alleged presence of asbestos, even the presence of asbestos is not clear, but that the alleged presence of asbestos created danger and cancer. An investigative result came back that different components could lead to a liability. So now it boils down to what's next. Johnson & Johnson was subject to different legal theories. First of all, it looks like a clear product liability. Product liability means that when the company manufactures something bad, they are liable for their product, and more important, for the injuries caused by their product. In the case of Johnson & Johnson, the plaintiff had argued that the baby powder was defectively designed and manufactured, and therefore caused them harm. The second argument is negligence. Negligence means that the company failed to use reasonable care. Maybe it was a quality control issue. Johnson & Johnson should have known that there's asbestos in the product and therefore should have put warning labels on. The third thought is fraudulent misrepresentation. This is a legal theory which makes manufacturers responsible for any injuries caused when there was an intentional misrepresentation or omission. Here, the Johnson & Johnson plaintiffs have argued that the company knew about the presence of asbestos and therefore they should have labeled it. So what are the lessons learned for you as a business owner, for you as a manager, as an operator of a company? The key lessons are, first, testing. Conduct thorough testing. It is crucial for manufacturing companies to have testing of the products before launch, during the manufacturing, quality control, testing, and then document your testing. In the Johnson & Johnson case, the early testing methods were called into question, and therefore, if the testing went wrong, the assessment of the safety of the product cannot stick. Number two, provide clear warnings. Any manufacturing company should provide a clear warning to the consumer. What is the risk and how can they avoid it? In this case, Johnson & Johnson plaintiffs argued again that the company failed to put any warning labels on the product. Number three, talk fast. If there is a concern out, argue not, but inform, share knowledge, provide background, share details. This will reduce the heat of the public, and Johnson & Johnson was criticized about not being early on and forward. Which leads to the fourth topic, be transparent. Manufacturing company should be transparent about their products, their testing methods. Why not create a YouTube series? Why not make something really fun out of it in order to share how the product is made and how the product has potential risks and how they can be avoided, or even better, describe the proper usage of the product. So what are the key takeaways? The Johnson & Johnson baby powder litigation was a long battle, and it would have been a much longer battle. The company has decided to deny the allegations, and therefore litigation for a long amount of time was on the door. As manufacturing companies develop new products, it's critical that the safety of the consumers is a key component, and any and all appropriate steps are taken to ensure the safety of the consumers and to make sure the product is free from defects and potential risks. How are you checking your company's products? How are you avoiding any risk for your customers? Share that with me. Would love to hear that.
Whether you're a private citizen, an international business leader, or simply someone eager to stay on top of the latest news, this book is a great way to get caught up on the most recent developments in the worlds of international business, tax, politics, and social affairs. Go to morningmusings.com and order your copy today.
Thank you for joining us today. If you would like more information about Bridge House Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. Bridge House Law, business-minded, client-focused.